Be ready. Start. By virtue of Clause 2, Subclause 9 of the Perpetual Lease Deed, the parties had agreed that a certain number of flats, as constructed under the terms of the Perpetual Lease Deed, would be leased to the UOI for accommodation of its officials at a fair rent. For the purpose of the present proceedings, two clauses of the perpetual lease deed are relevant, which says that so long as the war continues and for 1 year from the date the central government declared it as having ended, the Labour Department of the Government of India shall have the right to use the whole of the buildings or any part thereof, paying a rental assessed by that department on the basis of the capital cost. Even after the conclusion of the period mentioned above, the central government shall be entitled to require that a certain number of the flats not exceeding 50% of the total shall be leased to officials named by them at a fair rent as assessed by or under the orders of the central government. Further, nothing in the Transfer of Property Act 1882 contained shall apply or be deemed ever to have applied to any grant or other transfer of land or of any interest therein heretofore made or hereafter to be made by or on behalf of the government to or in favor of any person whomsoever, but every such grant and transfer shall be constructed and take effect as if the said act had not been passed. All provisions, restrictions, conditions, and limitations over contained in any such grant or transfer as aforesaid shall be valid and take effect according to their tenor, any rule of law, statute, or enactment of the legislature to the contrary notwithstanding. Clause 2, Subclause 9 of the Perpetual Lease Deed, upon which the UOI's case is based, entitles the central government to require that 50% of the flats be leased to its officials at a fair rent as assessed by or under the orders of UOI. Doubtless, the terms of the grant thus deprive the respondent of its ordinary contractual liberty to refuse to enter into a lease with the UOI. It is also clear that the respondent is bound to accept the lease at the rent fixed in accordance with clause 2 subclause 9. However, the question here is whether the entitlement of the UOI is absolute in the sense that it would even survive the failure of the UOI to pay the stipulated rent. There is no express stipulation to this effect, and I do not find any indication in the terms of the grant to support such a reading. In fact, to the contrary, the payment of rent is implicit in the clause itself. There is nothing in the terms of the perpetual lease deed to suggest that the grantee would not be entitled to avail of its ordinary remedies as a landlord in the event of the UOI failed to comply with the condition of payment of rent. To the extent that the absence of an express provision in this respect gives rise to any ambiguity in ascertaining the consequences of non payment, the benefit of the doubt must be given to the respondent. The judgments of this court mandate the interpretation of any ambiguity in a government grant against the government grantor and in favor of the grantee. It was further held that the construction of a grant would be in terms of the intention of the parties as revealed by the words used in their strict grammatical sense. However, any doubt as to construction must be resolved adversely to the grantor in accordance with the rule of contra proferentum. It was noticed that the English rule that crown grounds are to be construed strictly and in favor of the crown has not been adopted in our law as held by the Supreme Court in Delhi Development Authority versus Durga Chand Kaushish 1973 to SCC 825. Consistent with this approach, in the absence of an express provision to the contrary, the respondent cannot be deprived of its ordinary statutory remedies. The contention is that as the grant is of freehold estate without any reservation, it must, to take effect according to its tenor, be construed as granting exemption from assessment to revenue, but that will be extending the bounds of Section 3 beyond its contents. The object of the Act, as declared in the preamble, is to remove certain doubts as to the extent and operation of the Transfer of Property Act 1882 and as to the power of the Crown to impose limitations and restrictions upon grants and other transfers of land made by it or under its authority. Section 2 enacts that the provisions of the Transfer of Property Act do not apply to Crown grants. Then follows Section 3 with a positive declaration that all provisions, restrictions, conditions, and limitations over shall take effect according to their tenor. Reading the enactment as a whole, the scope of Section 3 is that it saves provisions, restrictions, conditions, and limitations over which would be bad under the provisions of the Transfer of Property Act, such as conditions in restraint of alienations or enjoyment repugnant to the nature of the estate, limitations offending the rule against perpetuities, and the like. Thank you.